The mission of the court and the justice system, of course, is to do justice, and not only to do justice, but also the appearance of justice. And it's important, as I mentioned before, that really and truly the goal is to do justice in case flow management. When cases are unnecessarily delayed, the confidence in our justice system, the public's perception is eroded tremendously. And the truth is, when cases are unnecessarily and unreasonably delayed to disposition, as we have all experienced, it clogs up and it impacts the other cases. It results in a tremendous amount of inefficiency. And what happens is that from a lawyer's standpoint, cases that you need to spend a lot of time on, you don't have that much time because you have this backlog of these other cases. And you end up spending a lot of time on this backlog that could have and should have been resolved in a just outcome early on in the process. So just unnecessary delays not only helps do justice or helps impede justice, but also the appearance of justice, which is important when we're talking about the media, we're talking about public perception, and so forth. And achieving justice means two things. That first of all, that the result is just, and also that the process is just. And I know that we've talked a lot about the process and representation and having adequate time to prepare and so forth. But the reality of it is that effective case flow not only results in a just result, but the process of getting there is just, and that there is that linkage between justice and timeliness. In any effective case flow management system, there has to be a reasonable and adequate opportunity for the parties and their attorneys to prepare for their case, however that case is going to be resolved. We're not talking, again, about just speeding up the process and not giving attorneys an opportunity to prepare their cases for whatever disposition it ends up. They have to have a process that gives them that reasonable opportunity to prepare. And what is reasonable? Well, that's going to be something that's going to be determined through the collaborative effort, through the planning process for a case flow management system for the implementation. And it's going to be determined through input from the bar, from the defense bar, from the prosecution, from the judge's perspective, as to what is reasonable in terms of time to adequately prepare. My point is that it's not something that's just mandated by the court. Okay, it's not just something coming in there. When I first became a judge, quite honestly, I was kind of disappointed because I thought all I have to do was order things and it would happen. In reality, it doesn't work that way oftentimes, most of the time, and shouldn't work that way. But it involves input because, as we heard this morning, what one agency or entity does in our criminal justice system would necessarily impact the other agencies in the system. I remember, I think, Mary Wiley this morning talked about how it's all connected together, and it is. And as a result of that, whatever processes and system that you design and implement, you have to have the collaborative, the input, the buy-in of all the agencies. That's how you develop reasonable processes, reasonable time standards, and so forth, with input from everyone. I'm sure that depending on the case and so forth, that reasonable time may be a certain length of time in a certain type of case and entirely different in another. And the judge may not understand all of those complexities without your input into that. caseflow management premise that is fundamental to any effective caseflow management system is that it's the court's responsibility to manage the case process. It is not the lawyers. Okay, the lawyers can settle the case, the lawyers can prepare the case, but it is the judge's responsibility to manage the process of that case, and that oftentimes, if you are going to implement a caseflow management system, you're going to need the assistance and the collaboration of the other judges. Now, I know in Texas there's a great deal of independence in the judiciary, and that some jurisdictions and some, as everywhere, in Florida also, that there may not be that collaborative or cooperation among the judiciary with all the judges, and you have to deal with that. And you have to deal with it in a way that you leave open the door for the other members to come along when they see the benefits and so forth. But you have to deal with that. And I think by and large that most of you are going to be working in jurisdictions where there is some cooperation among the bench. But it is the court's responsibility. I can remember as a defense attorney there was an unwritten understanding that the longer the case is delayed, the better it is for the defense. It kind of goes back to this deal about witnesses disappear, stories change, memories are lost, and so forth. And that one of the strategies in a lot of cases, hopefully it wasn't those that were incarcerated, was to drag out the process as long as possible, that you'd probably get a better deal. That lawyer with that particular philosophy, and I was one of them, you could not give them the responsibility of managing the case. It is the judges. It is he has and she has not only the responsibility, but also the authority and the power to do that in a effective way. The judge should manage that case, the progress of that case, from the time it is initially filed, all the way through disposition. And we're going to talk in a few minutes about the technique of doing that, the case management conferences and so forth that are a critical component of the effective case flow management. It's going to require a systems effort, and that the judges hopefully can work together and build consensus among the judiciary. The case management, one of the premises, aside in addition to the judicial responsibility, and truthfully, that really is the cornerstone. If the judge doesn't accept that responsibility, actively accept that responsibility, there is going to be no momentum or movement from a systems perspective and an individual case perspective to move that case along, to get it out of the system when it is fair and just, in a timely, expeditious manner. The judge is the only one that can do that. It requires a coordination of the court processes and resources, and the court can't do it alone. Hopefully there is some degree of collegiality, and also that other agencies buy into this, support this effort of designing and implementing effective case management strategies. All of the agencies involved in the case disposition process need to work together to ensure the case process is predictable, fair, and timely. So how do you get interagency collaboration? How does the judge, and I suggest that the judge is the one to do it. It was touched on a lot today, and How do you get other agencies to buy into it? What is one of the strategies do you think you would use? Anybody? Other than the court trying to mandate it. Any thoughts about this? Okay. Judge Carr? Buzz. Second judge. But how did you get your criminal justice stakeholders and agencies to buy into this case flow management system that you've implemented?
Well, we invited them all to the table. I mean, we were very proactive in making sure that everybody who would have a stake in it was there, and the momentum, I think, kind of propels everybody to come to the table for fear of being left out and not knowing what to do later. So, the people like clerks and the sheriff, I think they're going to naturally come, again, for fear of not being on the train when it leaves the station. So if there's enough momentum to start, if you build it, as they say, they will come.
Yeah.
You just got to start the process.
Yeah. And of course, you were the one who initiated the process. Yeah. And did you have an organization, a formal organization that Criminal Justice Planning Council or anything such as that you worked with? Or that you headed up as far as all the agencies' involvement is?
The other judge, who was the other co-chair, at some point she got in touch with Mary Sammons, who I heard somebody mention earlier from, I forget, she's from the National State Force. And so once we had a group of people together and indicated that we had a desire to go for the felony courts to go to that system, and then it was all agreed, and we were very collaborative in Tarrant County, and that's always been a good thing in our environment. So once it was all agreed that we wanted to do something with our system, then we sought outside technical assistance. And again, the process started moving, and once the thing starts moving, the momentum just keeps going.
I think one of the experiences that I've had in implementing systemic changes from a collaborative standpoint in bringing the people to the table, that they have to see a benefit to their particular entity, to their particular agency. Otherwise, they're not going to support it. If the public defender doesn't see a benefit to the public defender's office, they're not going to buy into this thing. If the prosecutor doesn't see a benefit to the prosecutor's office, why would they support that? So if county government, which plays a tremendous role in this system in terms of funding and support and so forth, if they don't see a benefit to it, if they just see it as a bottomless money pit, they're not going to buy into these changes. I think Hidalgo County, some of the comments today and how you did things were wonderful examples of getting collaboration and so forth. But it's got to be pitched first that they're going to benefit from this efficient case flow management system that you're trying to implement. And the other thing is that they got to have a sense of ownership. And you develop that by bringing them to the table. You develop that by giving them a voice in the process. And that they have a sense of ownership, a sense of buy-in. And when you get that, and when you get that system designed and implemented, one of the side effects of this is that there is developed out of this a system accountability. And what I mean by that is that when you work together closely, when you design this closely, when everybody has a sense of ownership, participation in this thing, you are able to hold the system accountable as a system. Okay, if that makes any sense to you. Throughout this process, and it's very critical to these things, you will identify issues that are impeding efficient case flow processes and management techniques. And the system working collaboratively, when everybody's there at the table, you'll be amazed. You'll be amazed where the solutions come from. And they come from from agencies and entities that had no idea it was a problem to begin with. So the system kind of holds itself accountable. The system develops this momentum that wants it to work the best it possibly can. And it doesn't mean that we diminish the responsibility or the proprietary interest that we have in adversarial criminal justice system. It means that working together to make the system best for everybody, and that we hold each other accountable in doing that. One of the major benefits of this, and one of the perennial problems, are resources. We've heard that over and over today. And again, I talked about the diminishing resources. When you have efficient, effective case flow system, and again, Mary Ann Riley mentioned it this morning, it generates resources. It frees up resources that are going to an inefficient system. Those are one of the things that are addressed. There were comments this morning, and again from the Hidalgo County, the chart that they had. It wasn't so much the chart in terms of the case flow, but some of the comments. Why does it take, I think, 20 days to get a case disposed of? Or why does it take 10 days to get a police report so that the prosecutor can make a decision on the charging and so forth? Those are issues that are discussed and identified because they directly impact the case flow. Okay, when you have this committee, or however you're going to design it, when you have this group that charts a case, and I'll talk about that in terms of statistics and data and so forth to collect, you will identify, not only in county court cases and district court cases, you'll identify mental health issues, or a process of identifying mental health issues quicker and so forth. And that y'all working together, y'all is a southern term, but working together, you will come up with solutions. And as I've participated in a couple of these conferences and did some other consulting work, when law enforcement's at the table, the arrest report issue surfaces, and they don't want to look bad. They don't want to be the only member of that committee who's going to be holding out things. That's that system's accountability. And in a couple of situations, they talking with everybody developed another process to get that timely. From a judicial standpoint, we did a study on jail overcrowding, and my part of it was to look at the court process and how does that court process, how does that case flow management process result in jail overcrowding. And one of the ways that it did in this particular study was that there wasn't events that were scheduled for early disposition of the case. And as a result, clients were sitting in jail, oftentimes unrepresented, that could have, as is consistent with justice and fairness and preparation and representation, could have been disposed of. And unfortunately, they couldn't make a bond, so they sat there. But this is that systems approach, that buy-in, that systemic response to the flow of cases through the process, criminal justice process, and how to get everybody on board. One of the things that it's going to require is judicial leadership. And I understand that in Florida, we have a chief judge for each circuit. And unfortunately, I was chief judge for a while. But that chief judge has a lot of authority, and it's a little bit different in Texas. Again, you're a little bit more independent, but it is going to take some judicial initiative and judicial leadership to get everybody there to get this going, if that's what you elect to do. Again, that happens on different levels and so forth. But everybody's got to be part of it. Everybody. Yes, Judge.
Judge, I think that judicial leadership can certainly be very effective, but I think also sometimes an official, a local official who is not
Sure. Yep.
I think judicial leadership can certainly be helpful, but I also think that it's very possible for other officials to bring
Yeah.
together.
You know, I agree with you. Most of the time, 90% of the time, or probably higher, it is generated out of judicial leadership. And I commend the county commissioner for doing that. I think he was effective in doing that, not only because of his leadership qualities, but also there was a perception of neutrality, that he didn't really have an axe to grind in this system other than improving the system for the benefit of his communities. That's the role or the position that usually the judge has of neutrality, and that I think is essential. It would be difficult, I suggest, to have the prosecutor try to lead that change, justice system change. So I agree with you. It can be done, but it takes the right individual and I think the right position to do that. Most of the time, from my experiences, when there's justice system change, it usually comes out of the active leadership of the judiciary because of that perception, not only of neutrality, but also power. You know, who was it said this morning, judges are not going to, can't tell you what to do, they can make you pay for it if you don't do it, though, or something such as that. And that hasn't had to do with this. But I think neutrality and personal leadership. So I commend the commissioner. That was a wonderful thing to do. Timeliness. You know, that's really kind of about what we're talking about. Yeah, please. The ABA standard defines it as any time other than reasonably required for the pleadings, discovery, and court events is unacceptable and should be eliminated. You know, again, we're talking timeliness, but in the same sentence, we're talking justice, fairness, reasonableness, and so forth. We're not trying to jam things down the system, the attorneys or whatever, just for the sake of getting things done earlier on in the process. It has to be fair, it has to be reasonable, and it has to give everyone an opportunity to prepare their cases. The court's management role. The court can manage the events and also manage the time between the events. But the lawyers, you know, they settle the cases. Judges don't. The lawyers represent their clients. The judges don't. But the judge can manage the events, the court processing events, and the times that elapse between those. And it is important, and it kind of goes back to this predictability that I talked about, that the events that are scheduled and managed by the court, that they are meaningful. Yet, you know, I retired about 2 or 3, 3 years ago, I think, but I fill in, and I was on the circuit bench, which is the felony analogous to your district court, but I fill in for a county court judge a couple of weeks, about a month ago. And, man, I was absolutely astounded at the differences and how the cases process and so forth. But what I found that, and I had one of these huge what we call cattle call proceedings, you know, to see if you're ready for trial. And I'm sitting up there, and the prosecutor and the defense said, you know, the case is going to be continued. The prosecutor doesn't have any objections. Well, I mean, I had an objection, but it didn't matter. You know, at least up until I said something, and I created chaos in that whole court event that day. But nothing meaningful happened. And it was predictable that the case was going to be continued because neither side objected to it. And it's going to be important that if we're going to have timely and just disposition of cases, that each event has to be a meaningful event. Again, it's meaningful in the sense that there is an opportunity to dispose of it if it's ready to be disposed of, if it's not going to go to trial, if it's totally prepared, and the lawyers feel comfortable in doing that, or something happens at that event that moves it significantly toward disposition, to a dispositional event. And there is a predictability that something meaningful will occur. That's important that the court can do. One of the things that we're going to talk about as far as the court event, managing the time and the events, the courts manage the time between events, which moves the case along long enough to allow lawyers to prepare and short enough to encourage preparation and to not simply delay.